The Irish government recently published draft legislation proposing to introduce Ireland's first investment screening regime. The purpose of the bill is essentially to give the government the power to screen transactions that could give rise to public order or security concerns in the state. The bill is significant in the fact that it proposes to introduce a mandatory and suspensory notification regime. This means that parties to a transaction that meet certain criteria in the bill are required to notify the minister at least 10 days prior to closing and are prohibited from closing the transaction until they receive a clearance decision. This has the potential to significantly delay closing. The minister has up to 90 days to issue a screening decision, and this timeframe may be further extended in certain circumstances. As currently drafted, the bill sets forth 4 main criteria for determining when a mandatory notification will be required. First, the transaction must involve the acquisition of an asset in the state or an undertaking in the state, and this may include minority acquisitions above 25%. Second, a third country undertaking must be a party to the transaction. A third country is any country outside the EU and EFTA. Third, the transaction must relate to or impact on critical infrastructure, critical technologies or dual-use items, the supply of critical inputs, access to sensitive information, or media plurality. And lastly, the value of the transaction must not be less than €2 million. One of the challenges posed by the bill is that it defines a lot of these items very broadly, including, for instance, what is an undertaking in the state or a third country undertaking. Suffice it to say for now that we're advising clients to seek legal advice if they're a party to a transaction that involves acquiring an asset or an undertaking that's in the state or that is outside the state but is owned, controlled or otherwise influenced by an Irish resident or an Irish undertaking, and any party to the transaction has connections with a third country. We will be able to guide you through the criteria to determine whether you're required to make a mandatory notification. We would encourage clients to start considering these issues now. Although the legislation is not expected to commence until 2023, the Minister will have the power to retroactively review transactions that close within the 15 months prior to commencement.